Hello everyone, a very good evening. So this is the marathon session for our module D, the last module of our syllabus. And today we'll be covering the most important units of our module D because it is not possible to cover the whole module. It is a lengthy module. So we'll be covering the most important units. The remaining units we'll be covering in the final marathon. All right. So try to be active, try to answer the questions, and be with me till the end. So let us start. Let us start with the first question of our module D. Module D is very important. Case studies are asked from module D. So I have many case studies, a lot of case studies for you today. Okay, first question. Which statements about a contract are legally precise? So first question from the Indian Contract Act. All contracts are agreements, but all agreements are not contracts. All agreements are contracts if consideration exists. Agreement enforceable by law is voidable. Agreement enforceable by law is always valid, irrespective of the competency. A contract is equal to agreement plus enforceability. So, what is a contract? If there are two people, A and B, A promises B to do some act or to provide something. So, A is the promiser who is making the proposal, right? B is the promisee. Now, B, if they agree to this proposal made by A, this will become an agreement. This is an agreement. Now, with this agreement, if enforceability is added, it also becomes enforceable at law. That means if the promise is breached by any party, A or B, then we can take this to a court and seek remedies and seek the damages. Okay? So, whenever there's an agreement between two people and there also includes an enforceability, then it will become a contract. So, all the contracts, they are agreements because before the contract, an agreement should be there between the parties. But all the agreements, are they contract? No. Only when there is enforceability along with an agreement, then it will become a contract. So, the correct answer should be 1 and 5. Yes, the correct answer should be 1 and even if consideration exists, agreement is not voidable if it is enforceable by law, and agreement enforceable by law will always not be valid. There could be other incompetencies like a lawful object, competency to contract, genuine consent is not there. This can be declared as void. Okay, so all contracts are agreements, but all agreements are not contracts. Okay, a 16-year-old student enters into an agreement with a mobile company to buy a phone on credit. Later, he defaults on the payment. The company sues him. Which of the following will be correct? Answer this question. In this scenario, in this case, a 16-year-old enter into a contract and they default. They do not fulfill, they breach the contract. What can the company do? The agreement is void ab initio. Minor is not competent to contract. Minor is liable to pay the damages. The company can enforce the agreement in court. So, what should be the correct answer? 1 and 2, 1, 2 and 3, 2, 3 and 4, and all of the above. So, when we are talking about the essential features of a contract, there's a point that the party should be competent to contract, competent to enter into a contract. This means they should be of majority age and they should be of sound mind. Okay. So, any contract which is entered with a minor is, what should be the correct answer? Any contract which is entered with a minor, is it enforceable or not in a court? It is not enforceable. It is void ab initio. Any contract entered with an unsound person, a person with an unsound mind, it is voidable. But a minor contract, it is void ab initio. Since the very initiation, it is not valid. And a minor is not competent to contract. So only 1 and 2. The minor won't be even liable to pay the damages. The company cannot sue him. The company cannot sue. They should have checked what is the age, whether this person is of the majority age or not, 18 plus or not. All right. So the correct answer is A, 1 and 2. Consider the following statements regarding a contract of indemnity. Regarding a contract of indemnity, which statements are correct? Section 124 covers only express indemnity, but courts have recognized implied indemnity in practice. An indemnity holder can recover costs only if he acted prudently or followed the indemnifier's instructions. The indemnity holder must always give notice to the indemnifier, and failure to do so automatically invalidates the claim. The term immediately means as quickly as possible. So, what is the contract of indemnity? Contract of indemnity means to protect someone. For example, an insurance policy. If I buy an insurance for my car and some damages are incurred on my car, I can claim these damages. I can make a claim to the insurance company to make good the loss, right? That is the contract of insurance. So I am the policy holder, I am the indemnity holder, and the insurance company is the indemnifier. All right. So regarding a contract of indemnity, which of these statements are correct? Which of these statements are correct? 1 and 3, 1, 2 and 4, 2 and 4 only, or all of the above? So when we talk about the indemnity, the Indian Contract Act basically covers express indemnity when there's a written contract, but the courts, they also give approval to implied indemnity, means something depending upon the circumstance of the case, right? An act done by one person at the instance of another, and manifestly it is not torturous to the knowledge of the person doing it. I'm doing something not to cause harm to the other person, but it turns out to be injurious to a third person. I will still be liable, right? I will be liable. I will have to pay the damages. It is implied, it is understood because of my act. If some loss is occurring to a third party, to another person, I have to pay for it. Okay, so there is an implied indemnity, not in the Indian Contract Act, but it is there as per the various court directions, jurisdiction of the courts, decisions of the court. Okay, so the first statement is incorrect. The first statement is correct. Second, yes, I cannot claim for damages for any unlawful act. I cannot claim for the damages from an insurance company by myself incurring some loss. If I have a fire insurance policy, I cannot myself put a fire and call for damages. No, only when I act prudentially. So this statement is also correct. However, giving notice to the indemnifier is not always necessary. All right. This is the meaning of implied indemnity. All right. And the term immediately means as soon as possible, as soon as reasonably possible. So the case that we had studied about the car was stolen, the person whose car it was, they reported to the police about the theft, but they reported it to the insurance company 1 month after. Will they still be eligible to get the insurance? Yes, because the courts have held that immediately implies giving notice as reasonably quick as possible, not the next day or not within 1 week. No. So the correct answer should be 1, 2, and 4. B will be the correct answer. Okay, this is the contract of indemnity. These are the features of the contract of indemnity. All right. X at the request of Y. files a suit against Z. X acts prudently and follows Y's instructions. The court orders X to pay damages and the litigation cost. Later, X seeks indemnification from Y. Which of the following is correct? So, X had filed a suit not recover the damages but can recover costs. X can recover only damages, not cost. X cannot recover anything since he voluntarily filed the suit. X can recover both damages and costs of Y. So, this is the section 125 of the Indian Contract Act. It deals with the extent of liability of the indemnifier, the promisee, right? What they can recover from the promisor or the indemnifier. They can recover all the damages which he may be compelled to pay in a suit, respect to which the indemnifier is providing the insurance, all the costs which he may be compelled to pay in any suit. All right, because the indemnifier is authorized to defend the suit. All the sums paid in compromise, they have the right to sue for a specific performance. So the correct answer should be D. X can recover both damages and costs of Y. When Y is acting as an indemnifier of X, it means all damages, all costs, all every anything that the person, indemnified person, all sums that they had to pay in the compromise, not contrary to the indemnity. All right, so the correct answer will be D. Right? X can recover both damages and costs from Y. A bank grants a loan to a company against a continuing guarantee executed by Mr. X. Later, Mr. X dies. The company continues to borrow under the same account. Which of the following is correct? Okay, so Mr. X has given a continuing guarantee to a company who can take a loan from the bank. Continuing guarantee means what? Guarantee means X is acting as a surety. This means that if there is the bank and there is Mr. X, sorry, the company, let's say company XYZ. Okay, any loan that XYZ takes from the bank, if they default, the Mr. X, who is the surety, they will be required to pay it. Okay. Now, this was a continuing guarantee. That means multiple transaction. But Mr. X had died, and the company continues to borrow under the same account. So the guarantee continues for all the transactions even after X's death. Guarantee stands revoked for the future transactions after the death of Mr. X. Guarantee stands revoked for the past transactions also. The guarantee continues unless expressly revoked by the legal hires. What will be the correct answer in the case of a continuing guarantee? In the case of a continuing guarantee. What is a continuing guarantee? Continuing guarantee which extends to a series of transactions. It is not limited to only one transaction but to many transactions. When a guarantee is of the nature, it applies from time to time for the amount due and payable from the principal debtor, the company to the creditor, right? In case the surety, however, when the surety dies, the guarantee ends from that date. It means now Mr. X, who is acting as the surety, they won't be liable. The legal hires, their nominees won't be liable for any debt that the company takes beyond the death of the surety. Okay, so the guarantee stands revoked for the future transactions after X's death. Normally, this happens, normally. However, not always. It depends upon the terms of the contract, right? The death of the surety operates if in the contract it is said that the legal hires will also be responsible. or another person's name is given, now that they will be responsible. Okay, but banks, they prefer to break the running accounts of a borrower when the surety dies. Okay, this is a case of a running account. Okay, so the correct answer will be B. The guarantee stands revoked for future transactions after the surety's death. Which of the following statements correctly describe the rights and liabilities of a surety? I need you to answer this question, everyone. Surety is regarded as a favored debtor, liable only if the principal debtor defaults. Surety's liability includes interest owned by the principal debtor. In a continuing guarantee, limitation period against the guarantor begins from the date of demand. Any variance in the contract terms between the creditor and the principal debtor without surety's consent discharges the surety for subsequent transactions. So, what is the contract of guarantee? There's the person A, let's say the person A is a creditor. There's the person B who is, let's say, a debtor. And there's a person C who is the surety. Okay, so guarantee means that whenever A is giving a loan to B and A is not sure, it is an unsecured loan, they're not sure whether A, the debtor B, will repay the loan or not. They're asking for a guarantee. So the guarantee that if B defaults, then the payment will be done by C. This is the responsibility of the surety. Okay, so if B defaults, C will pay back to A. Now A is out of the situation. They step out. Surety steps into the shoes of the creditor. Now the surety can recover their debt from B, right? The creditor cannot directly approach C. They can only approach C when the principal debtor has defaulted. Only when the principal debtor has defaulted. So the first statement is correct. The liability of the surety is coextensive with the principal debtor, only if the principal debtor defaults. Surety's liability includes the principal as well as the interest. In a continuing guarantee, limitation period against the guarantor begins from the date of demand. Correct. There's a limitation period within which the guarantor has to fulfill their liability. And if, let's say, the creditor and the principal debtor, they had entered into this loan contract saying that the rate of interest will be 5%. But now, without informing C, they have increased it to 6% with the intention of default. Will C be liable for this increased interest? No. Also, C can now step out of their position as a surety. So, all the four statements should be correct. The correct answer should be D. Yes, the liability of the surety is coextensive with that of the principal debtor. Only if the principal debtor is unable to pay the debt, the surety takes the place of the principal debtor, right? He can then claim from the principal debtor the entire sum. So the relation between the surety and the creditor is an express relation, express contract. The relationship between the surety and the principal debtor, it is implied, it is understood. It is understood that the principal debtor has to pay the surety. The surety will have the right over any security that the creditor had taken from the principal debtor. Doesn't matter whether they had prior knowledge about it or not. All right. Yes, so the correct answer will be D. If there are co-sureties, more than one surety to a contract, and one surety steps out of the situation, the other sureties will not be discharged. They still are liable. Right. X, a warehouse keeper, mixes Y's grains with his own grain with Y's consent. Later, the grain is sold. How will proceeds be shared? So, this is the contract of bailment. What is bailment? Bailment is the delivery of goods, movable goods, for a particular purpose, to perform a job, to do some business, right? And once the particular business is over, the goods are returned back. So the relationship is between a bailer and bailee. Bailer is the owner of the goods. Bailee is the person to whom the possession is transferred. Okay. So the entire proceeds belong to X. The entire proceeds belong to Y. Proceeds are shared proportionately between X and Y. Proceeds belong jointly, but only X can claim. Basically, if A was the bailer and B is the bailee, A has given some grains to B to sell in the market. B has also mixed some of his own grains, some grains that he grew on his own farm with these sacks that are provided by A. Right? Now, there can be two situations. With the consent of the baler, this mixing was done, or without the consent of of the baler, the mixing was done. Okay. So, what will be the scenario here? If the bailee, with the consent of the baler, mixes the goods of the baler with his own goods, the baler and the bailee will have an interest in proportion to their respective share in the mixtures thus produced. So the correct answer will be C. So if the total grains that were sold were, let's say, 1000 kg, out of this 1000 kg, 800 kg belong to A, the baler, 200 belong to B, the bailee. Then accordingly, 80% profit will be given to the baler and 20% profit will be given to the bailee. Right? They are shared in proportion. What happens if the bailee, without the consent of the baler, mixes the goods, their own goods with the baler? Now, if the goods can be separated, the property in the goods remain with the parties respectively, right? If they can be separated, the bailee is bound to bear the expense of the separation or division or any damage arising out of the mixture. However, in this case, these are grains. Grains cannot be separated. If the grains were kept in separate sacks, then they are separated. But if they are mixed together, they cannot be separated. So, if the bailee, without the consent of the baler, mixes the goods of the baler with his own in a manner that it is impossible to separate the goods and deliver them back, now the baler is entitled to be compensated by the bailee for the loss of the goods. All right, so the correct answer will be C. In this scenario, with wise consent, the mixing was done. So the proceeds will be shared proportionately between X and Y, between the baler and the bailee. Right? Consider the following statements regarding duties and liabilities of the bailee. Bailee who is in the possession of the goods, who's using the goods. What are the duties and liabilities? The bailee must take the same care of the goods bailed as he would of his own goods. The bailee takes such care. If they take such care, he is not liable for any loss, destruction, or deterioration of the goods. Any inconsistent use of the goods by the bailee makes the contract voidable at the option of the bailor. The bailee is liable to compensate the bailor for damages arising from unauthorized use of goods. So let's say some movable assets were transferred by the bailor to the bailee. Clearly they said that, let's say, a car was given. The car will be used only in cities on proper roads. This was the purpose. But the bailee, they took it on some off-roading and damages were caused. The bailee will be responsible to pay for the damages. They should have taken care. They should have not done something inconsistent with the contract, something inconsistent with what the bailer had said. Any damages arising, bailee will be responsible. However, if they took care, still the deterioration happens, now they will not be liable. All right? Yes, so the correct answer should be all of the statements are true. All right? The bailee must take care. If he takes care, he is not liable. Any inconsistent use of the goods makes the contract voidable. And if any loss happens due to unauthorized use of goods, the bailee will be liable. Otherwise, not. Okay. There is also the duty of the bailer. The bailer should disclose the material information about the goods, right? If he does not make such disclosure and any loss happens, any damage arises to the bailee, the bailer will be responsible for it. If the car had failed brakes and the bailer did not inform the bailee about it, and the bailee they faced damages and injuries, the bailer will be responsible, right? So the both the bailer and the bailee have duties and liabilities. Okay. Regarding the rules of agency under the Indian Contract Act, which of the statements are correct? Whatever a person can do personally can also be done through an agent, except the personal official acts. Acts of an agent are legally the acts of the principal. Principal must indemnify the agent for lawful acts, acts done in good faith, and injury caused by the principal's neglect. Principal has no right to recover the secret profits made by any agent. So, what is agency? When a person employs another person to do something on their behalf, to sign contract on their behalf, to enter into contract, to do anything on their behalf. This is the principal agent relationship, right? So there are certain responsibilities, duties and liabilities of the principal, duties and liabilities of the agent. What are the rights and duties of agent? Basically, the agent's duties are to carry out the work as per the directions given by the principal, rationally, with care, skill, and diligence. They should render proper account to the principal, to communicate the principal any important information. All the sums that are received from him should be payable to the principal. And without the knowledge of the principal, if the agent deals in the business on their own account and any profit arises from it, the principal is entitled to claim from that agent. For example, A, who is the principal, they give a direction to B, who is their agent, to buy a certain house for them. B tells A that it cannot be bought but buys the house for himself. A may, on discovering that B has bought the house, compel him to sell it to A at the price he gave for it. All right. So the correct answer should be 1, 2, and 3. Fourth statement is incorrect. All right. Fourth statement is incorrect. So there are two rules of agencies. First, whatever a person can do personally can also be achieved through an agent, except a personal action like marrying someone. Second rule, what he does through an agent, whatever act a principal does through an agent is actually an act of himself, right? So if the agent acts according to law and without any unlawful intention, they can bind the principal. Whatever contracts they enter into, it will be binding on the principal. Okay. A pledges goods worth rupees 50,000 to B as security for a loan of 30,000 rupees. B repledges the goods to C for 40,000 rupees. Later, A seeks redemption. What is A entitled to? What is pledge? Pledge is bailment of movable goods for securing a payment, securing a loan, securing a payment. Okay. Now repledging is allowed. If A has pledged goods to B, B can pledge goods to C, but to the same extent. The same extent what they have received. Right? So pledging of goods was 50,000, but the actual value of the loan is 30,000. B has pledged the goods to C for 40,000, more than that. So what will A receive? A must pay 40,000 to redeem the goods. A must pay 30,000 to redeem the goods. A cannot redeem as the goods are repledged. A must pay both B and C separately. What is A liable to pay? Who had pledged goods worth rupees 30,000 because the loan was 30,000. Will A be required to pay full 50,000 or 40,000 or 30,000, or they are not entitled to redeem the goods any further? What will be the correct answer? The correct answer will be B. Right? A must pay only 30,000 to redeem the goods because this was the loan taken by A. The repledging by B cannot be more than 30,000. If they made a pledge of 40,000, 10,000 they have to bear the loss. All right? So repledging of the goods is allowed. It is definitely allowed, but to the same extent. Where the pledgee further pledges the movable property, the pledge will be valid only to the extent of the interest of the pledgee, equivalent to the amount for which the property has been given to them as a security. So the amount is 30,000 rupees only. The amount of loan is 30,000 rupees only. All right, so the correct answer is B. Okay. Regarding stipulations in a contract of sale under the section 12. A stipulation essential to the main purpose of the contract is called a condition. Breach of a condition allows repudiation of the contract. Repudiation means cancellation. A stipulation collateral to the main purpose is called a warranty. Breach of warranty allows rejection of goods and cancellation of contract. Everyone who is present here, try to answer this question. Also, like the video, share the video. Just like the video and share it with other fellow aspirants so that they can also join. Try to answer this question. What is the meaning of a condition and a stipulation, a warranty? Basically, a sale can be an absolute sale or it can be a conditional sale. Now we are talking about the Sale of Goods Act, right? Sale of Goods Act. In the previous Indian Contract Act, we were only talking about the transfer of possession. In the Sale of Goods Act, we talk about the transfer of ownership because someone has paid a price for the goods. Absolute means nothing needs to be done to complete the sale. Conditional means something will be done, only then the sale will be completed. So there's also a difference between agreement to sell and the contract of sale. Agreement to sell means where the quantity and the quality is decided, the price is decided. Sale means when actually the goods are delivered and the price is paid. Now, this agreement will become a sale when only when certain stipulations are fulfilled. If these stipulations are compulsory to fulfill the sale contract, then it is known as a condition. It is important. But if it is only collateral, it is not important, not that important, it will be a warranty. All right. So stipulation essential conditional. Breach of condition allows repudiation. Stipulation which is collateral is warranty. Breach of warranty does not allow rejection of goods and cancellation of contract. No. Breach of warranty, there will be only the right to claim damages. All right. Whether it is a warranty or a condition, it depends upon the contract between the buyer and the seller. For some people, for example, color of certain goods or clothes is a condition. For others, it is simply a warranty, right? The color doesn't matter to them. So it will depend upon the buyer whether it is a condition or it is a warranty. He can even treat the fulfillment non-fulfillment of a condition as a warranty if he thinks that okay, doesn't matter, right? Which of the following rights are available to an unpaid seller whether property in goods has passed or not? who is an unpaid seller who has delivered the goods or is about to deliver the goods but they do not receive the payment. They get the knowledge that the buyer has gone insolvent, or they received a payment through a check and the check has been dishonored, it bounced. So what rights do the unpaid seller have? Right on goods, lien on goods while in possession. Lien means retaining the goods. Right of stoppage in transit. Let's say the goods are in transit, they have been delivered to the carrier to take it to the buyer, but they get the right knowledge that the buyer has been declared insolvent, they're unable to pay, so they can stop the transit. Right of resale, once they stop the transit, they have a lien over the goods, they can resell the goods to a third party, to a new buyer. The right of withholding delivery of goods. What will be the correct answer? What rights does an unpaid seller have? When the doesn't matter whether the goods have been passed or not. Lien on goods can be exercised while he is in possession only. If the goods have been passed, then lien cannot be exercised. So the first statement should be incorrect. Second is correct, third is correct, fourth is also correct, right? Right of stoppage in transit, if it is already with the carrier, they can give them the instruction to stop, bring it back. They can also resell the goods and they can withhold the delivery of the remaining goods. So the correct answer should be B. Lien is possible only when they have the possession of the goods. Okay, right, if he is only in possession. But here the question says whether the property in goods has passed or not. If the property in goods has passed, then lien cannot be exercised. In case of insolvency, he has the right to stopping the goods in transit and they have a right to resale. When the seller, they have possession, they can retain them until payment. If the goods have been sold without stipulation as to the credit, right, the buyer becomes insolvent, he has the right to sell the goods with or without giving notice, with giving notice to the original buyer or without giving notice to the original buyer. It is also an important point. Unpaid sellers lien under the section 47 can be exercised in which cases? Goods are sold without stipulation as to the credit. Goods are sold on credit, but the term has expired. Buyer becomes insolvent. The seller has obtained a decree for the price. Yes. So, what will be the correct answer? Section 47. Unpaid seller's lien. The unpaid seller of the goods is entitled to retain the possession until the payment of the price is made. Right? So, if the goods were given on credit, means that the payment will be done in parts, in installments. In this situation, lien can be there. If the goods were made on credit, but the time period for the complete installments has expired now, or when he has made part delivery, only 50% of the goods are delivered, the remaining are still with them, he has the right to retain the goods under these circumstances. The seller may also exercise the right while he's in possession, right, as an agent or a bailee. But if the seller has obtained a decree for the price, then they cannot have the lien. So either they can retain the goods or they can sell the good. Either the seller can retain the good or they can sell the good. Both together cannot be done. Right? So if they have obtained a decree for price, now they cannot use their right of lien over the goods. The correct answer will be A. 1, 2, and 3 will be the correct answer. All right, 1, 2, and 3. Effect of a subsale or pledge by a buyer. What is the effect of a subsale or pledge by a buyer? The unpaid sale. Basically, the buyer had acquired the goods. They did not make the payment to the seller, but before without making payment to the seller, they sold the goods to a third party. A is the seller who delivered the goods to B, who is the buyer. Buyer did not make the payment but took possession. B, without making payment to A, sold the goods to C. So, what will be the effect of this sub sale, or if the buyer pledged the goods to C? Unpaid seller's lien or stoppage in transit is unaffected by the buyer's resale. In all the cases, the unpaid seller's rights are defeated by the buyer's resale. Exception exists if the buyer transfers the goods of title in good faith for consideration. Exception also exists if the buyer pledges the goods. What will be the correct answer? The effect of subsale or pledge. So the first statement is correct. Yes, the unpaid seller's right of lien or stoppage is unaffected. In all the cases, the unpaid right is defeated. No. The unpaid seller will still have right over the goods till they receive the payment. Exception is, however, there if the buyer transfers the documents of title in good faith for consideration, right? And exception also exists if the buyer pledges the goods. So pledging is allowed, and in good faith they have transferred. C's rights will be there. The new buyer, they received the goods, they paid the price, and they got the possession. Their rights are also unaffected. The correct answer will be C, 1, 3, and 4. Right? The unpaid seller's right on lien or stoppage is not affected by a further sale or disposition of the goods which the buyer have made. If the goods are of a perishable nature, or if the unpaid seller has exercised his right of lien or stoppage, he also has the intention to resell, right? If the buyer does not within a reasonable time pay the price, he can resell the goods, right? This is where the giving of notice comes in. If the seller, before reselling the goods to a new person, if they give a notice to the original buyer, now if any loss has incurred, any damages he had to face, giving of notice, he can recover it from the buyer, right? On the other hand, if they give no notice, basically giving of notice, they do not need to share the profit with the buyer, but they can claim the damages from the buyer. Without giving the notice, they have to share any profit out of the next sale. Also, they cannot claim the damages. So giving of notice is basically a profitable thing for the seller. Okay. A buyer resells goods to C after purchase, but before paying the seller exercises lien. So what is C's possession? So the buyer, they took the possession, sold the goods off to a third person, and they did not make the payment to the seller. So what is C's possession? C is the new buyer. Okay, C is the new buyer. C acquires no title. C acquires the title only if he obtained the documents of title in good faith for consideration. C always acquires the good title. C acquires conditional title subject to the seller's consent. So when C, who is the new buyer, they buy the goods from the original buyer who has not paid the seller. How will C be responsible? It is not the fault of C. C had no idea that the person has not paid the price for it, right? However, they will acquire title only if they obtain the documents in good faith. Basically, if they had knowledge that this seller had no right to sell, they have not made the payment, then they will not have the title, they will lose their right. But if they have obtained the goods, obtained the documents of title in good faith for consideration, their right will not be damaged. Okay, so the correct answer will be B. The correct answer is B. All right. Consider the following statements regarding agreement in a partnership. Now we are starting with the Partnership Act. Partnership arises only from contract, not from status or inheritance. Agreement may be expressed, oral, written, or implied from the conduct. Partnership must have all the characteristics of a valid contract. Partnership can arise automatically by the operation of law. What will be the correct answer? What will be the correct answer? What is a partnership? As per the Partnership Act of 1932, when two or more persons who come together, they agree to share the profits of a business that they are carrying out, right? This is known as the partnership. So they are individually known as partners and together they are known as a partnership firm. It is not a separate legal entity. It is whatever the partners are doing. The partners are 100% liable to the firm. The contract, however, may be oral or it can be written, and it should be created. The partnership must be formed to carry on some lawful business only, and it should be to earn and share the profits. There should be a mutual relation of agency. All right. So, what should be the correct answer? The correct answer will be A, B, 1, 2, and 3. Automatically by the operation of law. Automatically by the operation of law, a partnership cannot be there. So, this is the essential characteristics. There should be an agreement between two or more persons for business, for profits, for mutual agency, right? And the partnership can be then at a partnership at will or for a fixed period or for a particular purpose. Automatically at law, no, it does not exist. Okay, so law means if let's say there's a Hindu undivided family or a Burmese Buddhist husband and wife, they are carrying business as such, they are not partners. The relations under a partnership, they arise from the contract, not from the status. All right, they always arise from a contract. A and B form a partnership for 5 years. After expiry, they continue business without a new agreement. What is the legal position? Partnership ends automatically. Partnership continues as fixed term partnership. The partnership transforms into a partnership at will. Partnership is void unless renewed. So there are three types of partnerships. Partnership at will is there. There's no specified time period or a particular purpose for which the people are coming together. There's the partnership for a fixed period. Let's say the three persons they come together to work for 5 years. Partnership for a particular purpose. This means they come together to run a business, run only one business. Once the goal is accomplished, now the partnership will end. Now, earlier, as per the situation, it was a partnership for a fixed period, 5 years. But after that, the end of the 5 years, they agree that they will not dissolve the firm. They will continue working together. Now, this will transform the partnership as a partnership at will. All right? No, the correct answer should actually be C. When there is no provision made by a contract between the partners about the duration or the purpose of the partnership, it is known as a partnership at will. It can be dissolved at any time by giving a notice, right? Also, it gets dissolved from the date of commencement of the notice. If the partnership is for a fixed period, in this scenario, 5 years, when two or more persons they enter into a partnership for a fixed period of time, at the end of the fixed period the partnership will end. However, the partners can continue to carry on the business after the fixed period has ended. Their mutual rights and duties will remain absolutely unaffected, and the partnership is automatically transformed into a partnership at will. It will not automatically end. And a particular partnership means for completing a particular job or an assignment. They can also continue it beyond the particular job, then also it will become a partnership at will. So the correct answer will be C. It is not A. The correct answer is C. All right? Yes. Under the section 12 of the Indian Partnership Act, every partner has a right to take part in the conduct of the business of the firm. Every partner must diligently attend to his duties. Ordinary matters can be decided by majority, but a change in nature of the business requires unanimous consent. Every partner has a right to inspect and copy books of the firm. So, what are the rights and duties of the partners? What are the relations of the partners to one another, relations of the partners to the firm? There are mutual rights, like the partner is not entitled to receive remuneration, but they're entitled to share the profits equally, right? Similarly, the partner has a right to have access to all the records, all the documents which are maintained. Partner is bound to attend diligently to his duties to act in good faith for the profit of the firm. They have the right to take part in the conduct of the business unless she or he is a sleeping partner. A sleeping partner cannot take part in the conduct of the business. Right? So the correct answer, actually, all the four statements are correct. The correct answer is D. 1, 2, 3, and 4. So these are the rights and duties of a partner, mutual rights and duties. Which of the following indemnities are recognized? The partners are responsible to indemnify the firm. The firm is also responsible to indemnify the partner. Implied authority of partners is there as an agent of the firm, right? So, which of the following is true? Firm indemnifies partner for the liabilities incurred in the ordinary course of business. So, in the normal course of business, if anything is done by the partner under their power, the firm is going to indemnify them. Yes, firm indemnifies the partners for acts done in emergency. If you remember the example, the firm is involved in selling fruits, right? A, B, and C are partners. C has the responsibility to sell them, but C is absent due to some reason. A sells the fruit in emergency because otherwise they are perishable. So, to protect the firm from the loss, they sell the goods. It is an act done in emergency, and this selling led to some losses, for example, at a lower price because A had no idea which market is profitable. Will the firm indemnify the partner? Yes. The partner indemnifies the firm for the loss caused by a willful neglect. Correct. If due to a willful neglect of a partner, any loss is caused to the firm, the firm will be liable to the third parties to whom the loss is caused. But they can recover it from the partner now. So this is also correct. The partner indemnifies the firms for losses caused by market fluctuation. No. Loss which was caused and the reason is outside of the partner's control. It is not caused by their neglect. The partner is not liable to indemnify the firm. Okay, so the correct answer will be A, 1, 2, and 3 only. All right. So, firm is liable for the wrongful acts of a partner because of the partner some injury or loss is caused to the third party. Firm will pay to the third party. They can recover it from the partner if it was done in the ordinary course of business. Similarly, any misapplication or misappropriation is done by the partner, the firm will be responsible for it to the third party. But again, the partner will have to indemnify the firm. All right. A, who is a partner in a grocery firm, enters into a contract to supply car spare parts in a firm's name and collects rupees 50 lakhs advance. Buyer sues the firm for refund. What is the firm's liability? The This firm is for a grocery business, but A has entered into a contract to supply car spare parts. What will be the correct answer? Firm is liable since the act was done in the firm's name. Firm is not liable since the act was outside the ordinary business. Firm is liable only if the majority partners ratify. Firm is liable jointly but not severally. What will be the correct answer? Everyone, answer this question. What will be the correct answer? The partner has done something which the firm was not involved in. Selling of car spare parts is not a business of the bank. Will the firm indemnify this or not? No. The firm will indemnify the partner only if the acts are done in the ordinary course of business. This act was outside the ordinary business, so the firm will not be liable. All right. This is the core principle. Okay. X, who is not a partner of the firm, represents himself as a partner in the firm. Relying on this, Y gives credit to the firm. Firm defaults, what is X's liability? So X is not actually a partner of the firm, but they are claiming that they are a partner of this firm, right? Y gives credit to the firm when asked, and the firm defaults. Now, in this default, what will be Y's liability? X is not liable since he is not a partner. X is liable only if the firm consents. X is liable personally as a partner holding out. X is liable jointly with firm but not severally. So this is the doctrine of holding out. When a person who is not at all a partner in a firm either represents himself or knowingly permits himself to be represented as a partner in the firm, and he induces others to give credit to the firm, then he is known as a partner holding out, right? Such stranger is liable individually and personally for the debts of the firm, as if he was actually a partner in the firm. All right. So this is the doctrine of holding out. The correct answer will be C. The correct answer will be C. X is liable personally as a partner holding out. All right. So even if they were not a partner, but they represented as a partner of the firm, they will be liable. What is the legal position of a minor after attaining majority? So normally a minor cannot be admitted into a partnership. That is, they cannot be made liable like other partners are 100% liable. But the minor can be admitted into the benefit of the firm. They can have a share in the profit. What will happen once they attain the age of 18? Minor must give a public notice within 6 months of attaining majority or knowledge of their admission as a partner in the firm. If no notice is given, minor automatically becomes a partner after 6 months. If he becomes a partner, he is personally liable for all the acts of the firm since the admission into benefits. If he elects not to become a partner, his share remains liable for the acts of the firm even after the notice, right? So when the minor attains the age of 18, within 6 months, they have to give a notice whether they want to become a partner or they do not want to become a partner. If they give this notice, then, or if they do not give a notice, then they will automatically become a partner within 6 months. Okay. If they give a notice that they want to become a partner, so their liabilities will continue as a minor up to the attaining of majority, and beyond that now they will be 100% liable. If they say they do not want to be a partner, they have the right to take and claim their shares and leave the firm. They will now not be liable to any act of the firm beyond the admission of the notice. Beyond the admission of the notice. Right? So if he elects not to become a partner, his share will not remain liable for the acts of the firm after the notice has been given. So the correct answer will be A, 1, 2 and 3. Alright, the correct answer will be A, 1, 2 and 3. Under the Section 45 of the Partnership Act, partners remain liable to third parties for the acts done before dissolution unless public notice is given. Estate of a deceased partner is liable for the acts done after his death. Estate of an insolvent partner is not liable for the acts done after insolvency. A retiring partner not known to the third parties as a partner is not liable for the acts after the retirement. So, there's a difference between the dissolution of a firm and the dissolution of a partnership. Partnership, if dissolved, it can be reconstituted, right? If let's say there are five partners, out of five, three leave, the firm can still continue. New partners can be made, can be included in the firm. However, if all the partners leave, less than two are remaining, this will lead to dissolution of the firm. Another point, for the partners can retire by giving a notice or as per the terms and contract, anything. If they become an insolvent, then also they will have to leave the firm. If the partner dies, then also they will no longer be a partner. So accordingly, what should be correct? The If the partners they decide to dissolve the firm, they will be liable till they give a notice, a public notice. Any act, anything which is done with a third party, they will be liable till they give a public notice. All right? Till they give a public notice. The estate of the deceased partner, however, will not be liable for the acts done after his death. The estate of a deceased partner will be liable for the acts done before his death, not after his death. Estate of the insolvent partner is not liable after insolvency, correct? Liable before insolvency. And a retiring partner not known to third parties as a partner is not liable for the acts after retirement. So the correct answer will be 1, 3 and 4. Okay. So if a partner is retiring, if a partner is retiring, after their retirement, they will not be liable if they give a public notice. Before the retirement, they will still remain liable. All right. Why? Because even after the dissolution of the firm or death or insolvency or retirement, the partners continue to be liable to the third parties for any act done by them until such public notice is given. All right. Yes. A, B, and C are partners. C retires and A and B continue the business. In a partnership firm, there are three partners. Out of these three, one has retired, A and B are continuing. What has occurred? Dissolution of the firm, dissolution of both firm and partnership, dissolution of the partnership, or no legal change has occurred in this scenario. What has happened? The firm is not dissolved, the business is being continued by the remaining partners. Only one partner has retired. So the correct answer will be this is only a dissolution or reconstitution of a partnership. Now only A and B are the partners in the firm, right? When there's a breakdown of a relationship or understanding between a few and not all the partners, the remaining partners can reconstitute the firm. This is called reconstitution or dissolution of a partnership. Okay. Under the section 69, 1 and 2, suits cannot be instituted. Now, a partnership firm, it is not mandatory to get it registered. Even when a written contract is there between the partners, they can decide to run an unregistered firm. However, there are certain disabilities if registration is not done. These disabilities are regarding filing suits against third parties. This is given under the section 69. So the section 69 suits cannot be instituted unless the firm is registered, the person suing is shown in the register of firms as a partner, the suit is against a third party, the suit is for the dissolution of the firm. So, what will be the correct answer? What will be the correct answer? This is the effect of non registration. As per the section 69, no suit to enforce a right arising from a contract can be instituted in any court on behalf of any person suing as a partner in the firm can be made unless the firm is registered. Similarly, no suit to enforce a right arising from the contract can be made on behalf of the firm against the third party unless the firm is registered. So, making a suit within or making a suit outside, not allowed unless the firm is registered. So, what will be the correct answer? The firm should be registered and the person suing the firm is shown in the register as a partner. So, the correct answer will be A. There are certain exemptions, however, right? This section will not apply to the firms or to the partners which do not have a place of business where in India, right? To any suit or claim or set off not exceeding 100 rupees, right? Similarly, the enforcement of any right to sue for matters relating to dissolution of a firm, right? This can still be brought before the court. Suit for the dissolution of the firm can be brought to the court even if it is not registered. This right is not affected by it. Otherwise, they will first need to get registered, only then the suits can be filed. All right. Which of the following are the correct distinctions? So now we are talking about the Companies Act. Correct distinctions between a company and a partnership firm. Company is managed by the board of directors, partnership is managed by the partner. Basically, what happens? The partnership under a partnership act, it is required whether or not it is unregistered doesn't matter, right? It can be registered, it cannot be registered. Company always has to be registered. Similarly, the partnership is the partners are the whole firm. If the all the partners leave, the partnership will end. But in a company, even if all the directors, all the members are changed, the company can still exist. There's perpetual succession. The company is a separate legal entity. They can sign contracts in their own name. They can own property. But a partnership firm is again whatever the partners are. Like this, there are the differences. The company has a perpetual existence, partnership does not. Shareholder can contract with a company. The partner, however, cannot contract with a firm. Can a partner be entered into a contract? No. Death of the member dissolves the company. Death of the partner dissolves the partnership. No, death of the member does not dissolve the company. All right, death of the partner can dissolve the partnership, yes, but the death of a member will not dissolve the company. The correct answer is 1, 2, and 3. Company is created by law, the Companies Act. Company can be dissolved only by law, otherwise not. All right, it is invisible, intangible, exists only in the eyes of law. It enjoys many rights of a natural person. A company has domicile, a company has residence, but a company does not have citizenship. If a company is registered under the Companies Act, it is an Indian company. It has residency and domicile. But citizenship is not given. It does not have the right to vote. Okay. Which of the following are advantages or exemptions available to a private company? Certain provisions are applicable to a public company only, and these are benefits to the private company. That is, they need not follow these provisions. A private company can be formed with only two members and two directors. They need not obtain certificate of commencement of business, need not hold statutory meetings or file statutory report. The restrictions on the board powers do not apply. So, what is the difference? Basically, what rights that are available with a public company or in a private company. So, a private company, yes, it can have only two members and two directors. Public company has to have minimum seven members and three directors. Private company, they need not obtain the certificate of commencement. Just the certificate of incorporation is enough. Public company has to obtain a certificate of commencement of business from the ROC. They have to obtain it. Private company need not hold any statutory meeting or submit a statutory report to the ROC. Public company has to do it. The requirements of appointment, remuneration to the directors payable, applicable to the public company, are not applicable to a private company. Annual general meetings have to be conducted by a public company, not a private company. Certain powers cannot be exercised by the board of directors without the consent of shareholders of a public company in a general meeting. This is not applicable to the private company. So the correct answer will be D. All of these are true, right? So there are some advantages of a private company over a public company. So the correct answer is D. Which of the following are mandatory requirements for a public company? Minimum of two members and five directors? No. Minimum of seven members and three directors required in a public company. Certificate of commencement of business is required. Holding statutory meeting and filing statutory report. Compliance with the restrictions. So the correct answer should be 2, 3 and 4. Option C. So there are different types of companies. Classification based on the liability. Company can be limited by shares, by guarantee, or with unlimited liability. When shares, then there's a share capital. Each share has a fixed nominal value, and if the company is being wound up, the members will be liable only to the unpaid amount on the shares. Guarantee, every member is given a guarantee that they will pay this much amount when the company is wound up. Unlimited liability, they're personally liable. Okay. On the basis of public interest, it can be a private company which do not have a public holding, do not issue shares in the market. They can issue shares, but only to its members. The members can be restricted to 200. They cannot issue prospectus. Public companies, already we have seen, they have a share capital and they issue the shares to the public, which can be transferred, sold, exchanged in the secondary market also. Government company, where 51% stake of the paid up capital is by the central government, state government, or both. Foreign company, not registered in the Indian Companies Act. A company or body corporate incorporated outside India, right? So these are the different types of companies. There's also the one person company and the small company and holding companies. Okay. Mr. A incorporates a one person company with paid up capital of 40 lakh rupees. After 3 years, the capital rises to 60 lakh. What is required? Nothing. The OPC will continue. OPC must convert into a private or public company within 6 months. OPC must reduce the capital below 50 lakh. OPC must dissolve. So one person company means a company which has only one person as the member. This person will also indicate the name of another person with their written consent, that if the subscriber dies or they're incapable to contract, now this person will now run the OPC, right? They can withdraw the consent at any time. They can also change the OPC person, they can change this person's name at any time. The requirement is that the at any time where the paid up share capital of the OPC exceeds 50 lakh, or its annual average annual turnover exceeds 2 crore rupees immediately in the preceding 3 consecutive financial year, the OPC will be required to convert itself into either a public company or a private company within 6 months, right? So the paid up capital should be less than 50 lakh and the average annual turnover should not be more than 2 crores. If it happens, they need to convert. Similarly, for the small company also, same provisions are there. Share capital does not exceed 50 lakh rupees and the turnover does not exceed 2 crore rupees. All right. So the correct answer is B. They will have to convert if the share capital increases. Consider the following statements. The Memorandum of Association states the fundamental objects and scope of activities of a company. The Articles of Association contain internal regulations. MOA is subordinate to AOA. Acts beyond the MOA are ultra vires. Both Memorandum and Articles of Association are public document. Whenever a company is established, they need to issue both of these. Memorandum of Association is what? It is the dominant document stating the name of the company, public limited, private limited, the registered office, the object, the main objective, and the ancillary objective, right? All of these things, the liability of the members, all of these things are given in the Memorandum of Association. Capital clause, association clause. Articles of Association is subordinate. It talks about the internal regulations. It also contains the provisions of entrenchment. Okay. So the correct answer should be 1, 2, and 4. MOA is not subordinate. If there is something which contradicts in the MOA and AOA, what are we going to follow? We'll follow the memorandum. So the correct answer will be B. 1, 2, and 4. Anything which is done beyond the MOA is ultra vires. It means that it is not within the power of the company. They cannot enter into such a contract or they cannot do such acts, and it cannot be ratified by shareholders. Anything beyond the AOA is a mere internal irregularity. It can be corrected, it can be ratified by the shareholders. So the correct answer will be B. Next question. A company's AOA requires quorum of 5 directors for the board meeting. A meeting is held with 4 directors and a resolution is passed. What is the legal position? The AOA says that any board meeting requires at least 5 directors, but only 4 are present. So, what is the legal position? This resolution is void, it cannot be ratified. The resolution is valid since the majority directors attended. The procedural irregularity can be ratified by the shareholders. The resolution is valid if the registrar approves. So I already told you that anything which is done inconsistent with the AOA, it can be ratified by the shareholders, but anything which is done against the MOA, it cannot be ratified. It is ultra vires. All right, it is ultra vires. Company wishes to shift their registered office from Delhi to Maharashtra. What is required? If we want to change anything in the MOA, this is the registered office clause. What is required? Ordinary resolution only, board resolution only, consent of the majority shareholders, special resolution and approval of the central government. Basically, any terms of the articles of association can be altered by a special resolution, but there is no approval requirement from the central government or any other authority. But The clauses in the MOA, like change in the registered office, or the object clause, or the name clause, or the liability clause, it can be altered only by a special resolution passed by the company. And along with that, the approval of the central government is also required. So the correct answer will be D. All right. Special resolution only for AOA. Special resolution plus central government's approval for MOA. Consider the following statements about the doctrine of ultra vires. Acts beyond the objects clause of the memorandum are ultra vires. They are void ab initio. If anything is given in the MOA and it clearly says that, let's say, the object clause of the company is manufacturing these and these goods, but the company enters into a contract to provide something else. It is ultra vires, it is void ab initio. Ultra vires cannot be ratified even by a unanimous consent of the shareholders. Correct. Intra vires means within the powers of the company. Ultra vires means beyond. It cannot be ratified. Company cannot sue or be sued on the ultra vires transaction. Ultra vires transaction is binding if approved. No, it cannot be approved. So if, let's say, there's a company XYZ who says that we are a company who is involved in the manufacturing of biscuits. All right. A person, Mr. C, comes into a contract with XYZ to manufacture clothes. The objective clause says only biscuits and other eatables. But they enter into a contract, one of the directors, they enter into a contract to provide clothes and they take the payment from C. Later on, the when C demands the goods, the company says that our object is to only produce, manufacture, and deliver eatables. And clothes is not our objective. So this is not a valid contract. Will their justification be right? Yes. Any contract which is entered by a third party beyond the powers of the company, it is void ab initio. Correct answer will be A. 1, 2, and 3. Both MOA and AOA, basically, they're public documents. Any third party who enters into the contract should have read them, should have understood them. Only then sign the contract. A breach of the MOA protects the company from the outsiders, right? But a breach of the AOA, the third party can still seek the damages because they are just irregular things or irregularities. But if the MOA is breached, the third party should have known that this power is ultra vires. It is not a power of the directors. It is a breach of authority. Directors induce outsider to contract with a company in ultra vires matter. Outsider suffers loss but had no knowledge of the ultra vires nature. What is the liability? The company is liable, the director is personally liable, outsider bears the loss, or the liability depends upon the shareholders' ratification. So, in this scenario, the person they cannot say that no, I had no idea about it. The third party they cannot say that I had no idea about it. Why? Because it is deemed to be a public notice and it is understood that everyone has read the document. But if it was not mentioned in the MOA that it is ultra vires and the directors they personally have entered into a contract, the outsider had no knowledge of the ultra vires nature, then the director will be personally liable to the outsider. The company will not be liable, the director will be liable. All right. Yes. So this is known as the doctrine of tracing. This is known as the doctrine of tracing. Basically, let's say the company says the directors cannot borrow anything from outsiders beyond 50 lakh rupees. But this is not given in their MOA, right? It is not given in their MOA. It is only an internal matter. Now, C, they enter into a contract with the director and they give them a loan. C, however, they cannot claim their loan from the company because it is ultra wires. But if they can locate the assets that are purchased by this director from the loan which is taken, 50 lakh rupees, if they're able to trace it, then they can use those assets, they can proceed against those assets for the recovery of the money due to him. This is known as the doctrine of tracing. Consider the following statements about the doctrine of constructive notice. MOA and AOA are public documents registered with the ROC. Outsiders dealing with the company are deemed to have notice of these documents, whether they have inspected them or not. Correct, correct. Outsiders have presumed to have understood the company's powers and the authority of its officers. Again, true. Constructive notice protects the outsiders by ensuring they are not bound by internal regulations. No. This is the doctrine of indoor management. If a third party enters into a contract with the company, they have read both MOA and AOA, and the contract is consistent with it. However, there is some internal irregularity and the article of association is not followed by the company, then the company will be liable and the outsider is protected. But constructive notice says that the company is protected from the outsiders. Any outsider who comes into the contract with a company that is ultra wires beyond the powers of the company, beyond the MOA, the outsider will not be protected. They cannot file a suit against the company. So the correct answer will be A, 1, 2, and 3. This is the doctrine of constructive notice. The public documents, MOA, they should have been read and understood by all the third parties. A company's MOA restricts its business to biscuit manufacturing. Directors enter into a contract with a supplier of milk bottling machinery. Supplier sues company for the breach. What is the outcome? Very easy. The MOA says that the only business is biscuit manufacturing. The directors against the MOA entered into a contract with a supplier for bottling machinery. So the supplier succeeds, indoor management protects him. The supplier fails, contract ultra wires MOA and void ab initio. The supplier succeeds if the shareholder ratify. The supplier succeeds if the directors acted in good faith. So in this scenario, the supplier will fail and the company is protected, right? He who deals with the company is deemed to have notice of the public document. Not only they have read it, but also they have understood. The doctrine of constructive notice is of a negative nature. It stops a person from arguing that he had no knowledge of the content of the public documents. Okay, so all the persons dealing with the company are deemed to have the knowledge of the company's AOA and MOA. It protects the company from the outsiders. The practical effects of the doctrine of indoor management include: outsiders need not inquire into the internal resolutions or approvals. If the MOA said that the directors can enter into a contract worth rupees 50 lakh personally, the AOA said that before entering into this contract, the ratification by three other directors is required, right? And there's a director A who entered into a contract with Mr. C, who is an outsider. So, in this scenario, MOA is also followed. AOA is also seen by Mr. C. He will assume that if A is entering into a contract, he has gotten it ratified by three other directors. Now, whether he does it or not is not a matter of concern of C. Okay, so the outsiders need not inquire into the internal resolutions or approval. The outsiders can assume that the procedural formalities have been complied with. Outsiders are protected unless they have actual knowledge. If it is a news, it is a well flowing news in the market that all the directors have left the company and only one is remaining, then how will this person take the ratification of other directors? If this person, Mr. C, has the actual knowledge and still enters into a contract, they will not be protected. Outsiders are protected even if the officers act outside the apparent authority. No. So the correct answer will be A. 1, 2, and 3. This protection is given only if the officers they act within their authority. Only if the directors, the officers, they had the power to enter into a contract. Right? So MOA, AOA should have been read. Whether AOA is followed by the company or not doesn't matter, the third party will be protected. Companies AOA authorizes managing directors to sign contract. A junior director signs a contract with the supplier. Supplier sues the company. What is the outcome? Only the managing directors can sign contract, but here a junior director has signed. So the supplier succeeds, indoor management applies. The supplier succeeds if the shareholders ratify. Supplier succeeds if the contract is intra-vires. Supplier fails because the act is outside the apparent authority of the junior director. Only the managing directors can sign contract. Any contract signed by the junior director will be void ab initio. All right. So if a person has the knowledge of internal irregularity or the act is outside the apparent authority of the officer, then the doctrine of indoor management won't work. The third party won't get protection. Regarding joint membership, so how can a person become a member in a company? Membership can be by subscribing to the MOA, allotment of shares, transfer of shares, transmission of shares, acquiescence, beneficial owner, or a joint membership. So, regarding the joint membership, notices and dividends are sent to the first named joint holder. All joint holders are treated as a single member. Each joint holder is counted separately for the quorum purposes. Joint membership arises when the shares are held in joint name. So when two or more persons they hold shares in a company in their joint name, it is known as joint membership. They are treated as a single member, and in such a case, the name of the member appearing first is considered to be the main member for the purpose of sending notices, dividends, etc. So the correct answer will be 1, 2, and 4. They are not counted separately. Okay. Mr. X subscribes to the Memorandum of Association of ABC Limited. Later, he alleges fraud by the promoters and seeks to rescind his membership. What is the outcome? As per the Companies Act, the subscriber of the memorandum will be deemed to be a member when the company is being registered, incorporated, the original subscribers. Hence, on registration, he will be entered as a member of the company. Now, the subscriber will be deemed to have agreed to become a member. Neither application nor allotment of shares is necessary. And thus, a subscriber to the MOA cannot rescind the contract for the purchase of shares even on the ground of fraud by the promoters. He cannot rescind, he cannot cancel the contract. Subscribing to the MOA is binding. All right. So the correct answer will be B. Yes. Consider the following statements which are correct. Any person competent to contract can become a member of the company. Yes. A minor can apply for shares and become a member but incurs no liability. No. Minor is incompetent to enter into a contract. They cannot become a member. They can only be entered as a beneficiary. Otherwise, minor and persons of unsound mind, they cannot become a member. If they are by mistake recorded as a member of the company and the minor, they can rescind the transaction, they can remove the name from the register. If the minor has been allotted shares and they are entered into the register of members, he incurs no liability until they are of the minority age. Okay, so normally they cannot be entered as a minor. A partnership firm can hold shares in their own name. Can a partnership firm become a member of a company? No. Why? Because a partnership is not a separate legal entity. The partners can become a member of the company, but the partnership firm cannot become. A company can become a member of another company if it's authorized by MOA. Company is a separate legal entity. They can become a member of another company if authorized by the MOA. So, who can be members? Competent persons. Minors or unsound mind cannot be member. They have no liability. Companies, LLPs, societies, trade unions can be members. Partnership firm cannot because they are not a legal person. Non-residents can, but subject to the FEMA compliance, otherwise not. Insolvent person, if they were a member and they become insolvent, they will remain the member, but they will lose the beneficial interest. Fictitious persons, if they take the identity of some other person and they enter into the membership, this again will be contravention. It is a criminal offense, punishable offense. Mr. X, who is a non-resident, acquires shares in an Indian company without RBI approval under FEMA. Later, he claims the dividend. What is the outcome? Claim is valid. Non-residents can freely hold shares. No. Claim is invalid because the FEMA compliance is required. Without FEMA compliance, a non-resident, a foreign person cannot become a member of an Indian company. Okay. Compliance requirements for a prospectus include: prospectus can be issued only after incorporation of a company. Prospectus must be dated and signed by every director or proposed director. Every application form for shares must be accompanied by a copy, except for underwriters and existing shareholders. Prospectus remain valid indefinitely once registered with the registrar. No. When we are talking about the prospectus, it is issued when the company is issuing shares in the market, right? The time of issue of the prospectus should be mentioned, the content should be correct, the date of publication should be there, signature of every director should be there, application form will be accompanied, statement by experts should be there. But once the prospectus has been delivered to the ROC, it won't be valid if issued more than 90 days after the date on which the copy is delivered to the ROC, right? So when the company delivers their prospectus to the ROC, they need to issue the prospectus within 90 days, otherwise it will become invalid. So the correct answer will be A, 1, 2 and 3. Which of the following situations require issue of a prospectus? Invitation to enter into underwriting agreement, offer of shares only to existing shareholders, offer of shares uniform with already listed securities. These do not require issuing a new prospectus, but offering shares to the general public requires a prospectus. So this is the concept of a shelf prospectus. All right, shelf prospectus. Then consider the following statements about civil liability for the misstatement. Basically, the expert's role is to make sure that everything which is given in the prospect is correct. However, a person who has been induced to subscribe for shares or debentures on a faith of a statement, but in reality something is untrue, they will have remedy against the company as well as remedy against the promoters and experts who were responsible for the issue of the prospectus, and the liability can be civil or criminal. So civil liability, a shareholder is induced by untrue statements, they can rescind the contract, they can cancel the contract, yes. Damages can be claimed from the company whether the statement was fraudulent or innocent, yes, damages can be claimed. Promoters will also be sued. However, civil liability will arise only if the statement was fraudulent. No. Civil liability will arise even if there's an untrue statement. All right. Even if there's an untrue statement. All right. So, remedies against the company, they can rescind the contract, they can claim damages. Criminal liability, fa- it is required that certain matters should be correctly reported in the prospectus. Failure to do so, the director, the experts, the promoters will be punishable with fine. Every person who is responsible for the untrue statement will be punishable with fine or imprisonment or both. All right, so the correct answer will be A. The board composition under the section 149. This is regarding the directors in a company. Minimum three directors in a company and two in a private company, and one is required in the OPC. Correct. Maximum 15 directors should be there. Extendable by a special resolution. Yes, that is also true. Okay. Every company should have at least maximum, then at least one woman director in the prescribed classes of companies, at least one third independent directors in every listed public company. So when we are talking about the requirement of up the directors, minimum 3 directors, maximum 15 directors, at least one woman director, one third directors who have stayed in India for not less than 182 days in the previous calendar year, right? Similarly, one third will be independent directors, and within this one third, the central government can prescribe the minimum number of independent directors. Independent directors mean who are, in the opinion of the board, person of integrity, they have relevant expertise. If someone was a promoter of the company, they're related to the company, not allowed. If they have a pecuniary relationship other than remuneration, not allowed. If the relatives are holding security of the company beyond a certain threshold, not allowed. Right? They should not have any substantial interest. So these are independent directors. The correct answer will be D. All of these statements are true. Yes. Mr. X, an independent director, earns consultancy fees from company amounting to 25% of his total income. Is he validly appointed or not? He's earning 25% of his income as consultancy fee from another company. Is it valid or not? Yes, consultancy fees permitted. No pecuniary relationship exceeds 10%. This is the meaning of substantial interest. Okay, not more than 10% is allowed. And here they are holding 25%. So their appointment is invalid. All right. The person should have no pecuniary relationship other than remuneration or having transaction not exceeding 10% of their total income with the company, its holding, subsidiary, associate company. Consider the following statements about the appointment of directors. If the articles are silent, subscribers to the memorandum are deemed as the first director. Subscriber to the MOA are the first directors. Yes. In a OPC, the sole member is deemed the first director until appointment. Again, true. They will also name another person. Every director must have a director identification number. Yes. So if they want to be appointed, first they will get this director identification number. Only then they can be appointed. Independent directors are not included in the total number of directors for the rotation purpose. Basically, a person who is appointed as a director, They can be retired on the rotational basis, right? Retirement of directors at every annual general meeting is done. But independent directors are not included here. All right, independent directors are not included. Okay, so the directors are to retire by rotation at every annual general meeting, those who have been the longest since their last appointment. Okay, so that is the correct answer. But independent directors will not be retired in the rotation. At the annual general meeting of a public company, three directors are liable to retire by rotation. Two were appointed on the same day and one was appointed earlier. So who retires? All three retire. Director longest in the office retire. Two appointed on the same day retire. Retirement determined by the lot among all three. So, persons who became directors on the same day, if the directors are to retire by rotation at every AGM, shall be those who have been in the longest in the office since last appointment. But as the persons between persons who became the directors on the same day, those who are to retire shall in default, subject to any agreement among themselves, will be determined by the lot. So between the two directors on the same day, the majority will decide it. But in this scenario, two were appointed on the same day and one was appointed before them. So the director who has been longest in the office will retire. If all of them were appointed on the same day, then the majority will determine who is going to retire. Okay. Loans to the directors are prohibited except loans to the directors' relatives with the shareholder approval. Is giving loan to the director exempt? No. Loan to the director's relative is not allowed. So this is incorrect. Loan to a wholly owned subsidiary is allowed. Guarantee or security to the subsidiary is allowed. Loan in the ordinary course of business by the banking company is allowed. The correct answer will be D, 2, 3, and 4. No company shall directly or indirectly advance any loan to its own directors or any person in whom the director is interested, or give any guarantee or provide any security with a loan taken by the director or their relative. However, if the loan is given to its wholly owned subsidiary or guarantees given, it is exempted. All right. So, loan to the director's relative is not exempt. Other situations are exempt. Last question for today. Consider the following statements. The board can make calls on the shareholders only at a board meeting. Borrowing money otherwise than on debentures requires a board meeting resolution. Issuing securities, including debentures, can be approved by circulation. Approving amalgamation or the merger requires deliberation in a board meeting. Basically, here we are talking about the rights or powers that can be exercised only at the meeting of the board. There are some significant matters which need deliberations and discussions. Okay, the board of the directors, they have general powers to do all the acts on behalf of the company, but certain powers can be exercised only at meeting of the board, not by circulating papers among the directors and passing the resolution by circulation. What are these powers that can be deliberated only in meeting? Make calls on the shareholders in respect of money unpaid on their shares. Issue securities, including debentures. Borrowing money other than on debentures. Invest the sum funds of the company. Make loans. Authorize a particular buyback. Diversify the business of the company. To approve amalgamation, merger, or reconstitution, and to take over a company or acquire a substantial stake in another company. All right. So the correct answer should be 1, 2, and 4. Issuing securities, including debentures, cannot be approved by circulation. This also requires a board meeting. So the correct answer will be C, 1, 2, and 4. Certain restrictions are there on the powers of the board, right? The board of the directors of a company can exercise certain powers only after a resolution is passed, like dispose any undertaking of the company, remit any debt due by a director, invest otherwise than in trust securities, borrow money in excess of the aggregate paid up capital, contribute to charitable and other funds more than 50,000 or 5% of its average net profit. This is also restricted. So that is all for today. We have completed the most important units of Module D. Now we are left with the Limited Liability Partnership Act, the Transfer of Property, Right to Information, and Information Technology Act, and Prevention of Corruption Act. These acts we will cover day after tomorrow. Now, tomorrow you have the final marathon of your ABFM paper. The exam is on 13th. So, tomorrow we won't be having any marathon session on YouTube. Now, I will meet you at 6 p.m. on 13th. 6 p.m. on 13th, we will revise all the modules once again. Theory of the most important topics and MCQs of the other topics. This session will probably go on till 10 or 11, not more than that, and we will revise the whole four modules. All right. We have the capsule lecture tomorrow in the morning at 7 a.m. and the final marathon day after tomorrow at 6 p.m. Right. And this is the QR code for your for the Telegram channel, JIBCIB official Oliveboard channel. All right. So you can scan here and you can join the group. All the quizzes, polls, updates, information, everything you are going to get here. So that is all for today, and I will see you in the morning at 7 a.m. and then on 13th at 6 p.m. Make sure that you attend both the classes. And before you leave, like the video, subscribe to the channel, comment down below if you have any doubts or any queries. All right. So thank you so much for attending. Revise the topics, download the PDF, go through all of these explanations. All right. So good night, take care, and all the best. And I will meet you tomorrow in the morning.